The injunction against the Rhode Island magazine ban has been denied, and the judge has spit in the face of Bruin. Let's go ahead and talk about it. What's up, Wolverines? Are you ready to be furious? Because you are going to be furious. I just wrote an article about this case, and I am furious. And if you're going to be furious, you might as well be furious by wearing one of these. It's a John Crump Wolverines t-shirt with a design by our friends over at Frag Out Designs. They are a great company. Okay, so let's just jump into this case, because the more I think about it, the more I'm getting pissed off, and I don't want to go hawk mode on you guys. All right, so a judge in Rhode Island ruled against a lawsuit brought by Ocean State Tactical and 4 citizens of Rhode Island over the Rhode Island large capacity feeding device law. This law was passed on June 21st, and it went into effect after 180 days. And it bans any magazine holding more than 10 rounds. And if you own one of these magazines, you have several different options. The first option is to sell it to a firearms dealer out of state, or you can modify your magazine permanently to hold only 10 rounds, or you can turn it into state police. Now, the plaintiff in this case thought this was blatantly unconstitutional, which I agree. They claimed it violated several different amendments. The First Amendment is the Second Amendment, because it limits your ability to protect yourself and others and from a tyrannical government. But, people just don't talk about the tyrannical government part. The judge flat out denied this by stating that magazines are not arms and not protected by the Second Amendment. Even though if you have a magazine-fed gun and you outlaw magazines, you can render all magazine-fed guns, which is the majority of guns in the country, as inoperable. But, this is an Obama-appointed judge, so he's going to be anti-gun. And get this, he also said that magazines, even if they were arms, would still be able to be banned because they show little effect on self-defense, which is not the purpose of the Second Amendment. Legal scholars would disagree with this judge, but once again, he's an Obama-appointed judge, so he's going to be doing what he will do. The plaintiffs also claim that the law violated the Takings Clause. The Takings Clause says you have to be justly compensated for anything that the government takes. The judge stated that the law did not violate the Takings Clause because it is within the right of the state to police firearms and to confiscate magazines without confiscation, which is not found anywhere in the founding documents at all. Now let's get into the 14th Amendment violation. The plaintiffs claim that the right to due process was being violated in deprivation of rights under the color of state law. They asked for a preliminary injunction from the judge, and the judge flat out said no, because he found that they were not likely to succeed on the merit of the case. In order to get a preliminary injunction, you have to show that you can succeed on the merits of the case and that you have irreparable harm. The judge denied both of these, and we're going to talk about why he did it. The judge claimed it was within the power of the police to confiscate magazines without compensation. And I'm going to read to you a quote that he said. He said it will lower the risk of harm that results of the availability of devices that can assist someone intent on murdering a large number of people. And he also called the law common sense public safety legislation, which is kind of like a buzzword from the left, I think. Maybe I heard that from Moms Demand Action, Everytown, Giffords, and every other anti-gun group out there. Since the judge ruled that magazines are not arms, he could use public interest in his ruling, and that's exactly what he did. He said there is an epidemic of violence in American society. There has been layered the ultra-lethal pathogen of mass murder shootings in which multiple people are killed and often dozens are injured. He thinks that magazines somehow make mass shootings more deadly. In one part of the lawsuit, he says it's impossible to reload a magazine within 2 to 3 seconds. And the second part, he says it is possible, and that is what he uses in the case, which is amazing to me. He further doubles down on this by saying while magazines does not prevent mass shootings, it makes them less deadly, and then says that the plaintiff's injunction pales into comparison to the unspeakable definition. What's really interesting to me is in one part of the lawsuit, he claims it's impossible to change magazines within 2 to 3 seconds. And in this part, he claims that it's possible to change magazines within 2 to 3 seconds, which is kind of ridiculous. He goes further, though. He says while the ban on LCMs, large capacity magazines, does not prevent mass shootings, it makes them unquestionably less deadly. And then he tries to say that the plaintiff's harm is outweighed by the unspeakable devastation caused by mass shootings, wildly spreading bullets without end into crowds of bystanders. The judge is very, very anti-gun. He also states that the law does not violate the Constitution because people are free to have as many magazines as they want. He also states that shooters can have hundreds of magazines at their feet ready to shoot at the range, which is kind of dickish for him to say because he says it in such a mocking manner. He also dismissed every expert witness of the plaintiffs while accepting every expert witness of the state, which I thought was kind of ridiculous, but even Obama appointed judge doing anti-gun stuff. One of the most shocking things is that he said that licensing schemes, such as the one in Oregon, which has been knocked down by multiple courts now, is constitutional. We are so happy that he is not out in Oregon judging those cases because they all got preliminary injunctions against them, including the GOA case that got a preliminary injunction against the magazine ban out there. So let's see where this case goes, but this judge is definitely anti-gun and shows his disdain for the Bruin decision and constitutional rights as a whole. All right, guys, that's it. I hope you have a great day. Stay ever vigilant, stay ever free, keeping the fight. I am out of here. Wolverine's mother.